Good day, ladies and gentlemen. This is Dr. Frel, your professor.
Hello class, good morning. Our next topic for the course is about covered employees under the labor code. So we have three objectives for this topic. First is to explain the concepts of compassionate justice, labor, and capital. Second is to identify the different classifications of employees. And the third is to explain the rights of employees and the requirements implied in its kind of employment. So what is this concept or the doctrine of compassionate justice? This is actually applicable under the premises that private respondent being the breadwinner of his family. As such, the social justice policy mandates a compassionate attitude towards the working class in its relation to the management. This idea of compassionate justice was made famous by Martin Luther King Jr. and of course Mahatma Gandhi, because Mahatma Gandhi's claim for democracy, for citizenship rights and freedom on the basis of non-hatred, non-violence, and dignity is an example of compassionate justice. So by this class, in consonance with the purpose of fostering social justice as the underlying principle in labor laws, courts and labor tribunals utilize compassionate justice in its decisions and rulings by disregarding certain rigidities in the rules and giving considerable weight to all possible equities in each case. As far as labor and capital, the law provides for the protection of labor as the legal maxim that just goes like this: those who have less in life should have more in law. As far as labor is concerned, class, please be reminded by this quotation from the book of Adam Smith, The Wealth of Nations, published in 1776. According to him, no society can surely be flourishing and happy of which the greater part of the members are poor and miserable. It is but equity besides that they who feed, clothe, and lodge the people should have a share of the produce of their labor. So by this class, be reminded that the law is intended to establish a common thoroughfare that is fair and reasonable to both labor and capital. And any dispute between labor and capital arising from employment shall be resolved internally, mutually, and without intervention from the state or other institutions. So as if class that the goal of labor laws is to strike a harmonious relation between labor and capital so that economic and social progress shall be best achieved. We cannot simply tolerate injustice to employers if only to protect the welfare of undeserving employees. So the Constitution is committed to the policy of social justice and the protection of the working class. It should not be expected that every labor dispute will be automatically decided in favor of labor. Now let's proceed with the classification of employees. First classification is that of special workers. And under this special workers, one is those that falls under apprenticeship under Article 57 of Presidential Decree 442. So this apprenticeship is a practical training with a minimum of 3 and not exceed 6 months. And there is, of course, an arrangement period, and most probably this is a hands-on training. So these apprenticeship are usually requisites in a business that is considered highly technical industry. Examples are trade, business, enterprise, or the application of advanced technology and the like. So those workers who are apprenticeshable are those that falls within the age of at least 15 years old, and their wage rates should not be below 75% of the minimum wages. So I have a question, class. Is hiring of apprentices without compensation allowed? So according to Article 72 of the Labor Code, this is actually allowed. So on-the-job training as part of the training program of curriculum or requisite for graduation or for board examination. And under this apprenticeship, there is no employee or employer relationship, but there is actually a written agreement. And always remember that the privilege to study, which is free of charge. The second classification under special workers are those who are considered learners. So these are those that may learn through practical training for 3 months. And they are being employed when no experienced workers are available in order to prevent some curtailment of employees. So these learners are persons hired as trainees in semi-skilled and other industrial occupations which are non-apprenticeshable and which may be learned through practical training on the job in a relatively short period of time which shall not exceed 3 months. In this case, class, their wage rate should not be below 70% of the minimum wages. So under this classification, class, 2 months shall be deemed regular employees or terminated by the employer before the end of the stipulated period through no fault of the learner. Then the third one, class, is that of the handicap workers. According to Article 40 of the Labor Code, handicap workers are those earning capacity is impaired by age or of physical or mental deficiency or injury. This is supported by the Magna Carta for the Disabled Person or Republic Act 7277 that provides that no disabled person shall be denied access to opportunities for suitable employment. So this can be elaborated, class, that a qualified disabled employee shall be subject to the same terms and conditions of employment and the same compensation, privileges, benefits or fringe benefits, incentives or allowances as a qualified able-bodied person or worker. Next, we have the minors, under Article 137 of the Labor Code. It provides that no child below 15 years of age shall be employed. But there is an exception. That is when he works directly under the sole responsibility of his parents or guardian, and that his employment does not in any way interfere his schooling. So under this case, who may be employed? Class. So any person between 15 to 18 years of age may be employed for such number of hours and periods determined by the Secretary of Labor in appropriate regulations. Again, class, no person between ages 15 to 18 may be employed in any hazardous work. So you may ask, class, regarding this minors, It's because we see minors working everywhere at almost any time of the day, especially on the streets, particularly in cities. But the law is specific as regards the standards that must be observed in employing minors. So earlier I have mentioned of hazardous work. So hazardous child labor is work in dangerous or unhealthy conditions that could result in a child being killed or injured or made ill as a consequence of poor safety and health standards and working arrangements. So it can result in permanent disability or ill health or psychological damage to the child. So again, class, even if there is a provision under the code that each a minor can be employed, but is still no person between age of 15 to 18 may be employed if their nature of work is seen to be hazardous. So again, class, this hazardous environment includes dangerous environmental elements or radiations or chemical or fire or flammable substances or explosives, no? Or if they are employed as a construction worker or in logging concessions or firefighting, mining, quarrying, blasting, or stevedoring, or dock works, or deep sea fishing, or mechanized farming, or those where miners are exposed to heavy or power-driven machinery or equipments. In addition, class, Republic Act 9231 Section 12 provides that minors should be the sole responsibility of his parents, and they are allowed to work not more than 20 hours a week or not more than 4 hours a day. And of course, he does not work between 8 o'clock in the evening and 6 o'clock in the morning. Another class, Republic Act 7610, provide that where child employment or participation is essential in public entertainment, in cinema or theater, radio, or other forms of media, the contract has to be signed by the parents or the legal guardian of the child. Then the next classification under special workers are those that falls under women. So Article 2, Section 14 provides that the state recognizes the role of women in nation building and shall ensure the fundamental equality before the law of women and men. Class, here I am referring to the Philippine Constitution. In addition, Article 13, Section 14 also provides that the state shall protect the working women by providing safe and healthful working conditions, taking into account their maternal functions in such facilities and opportunities that will enhance their welfare and enable them to realize their full potential in the service of the nation. So, this can also be elaborated that being a woman should not be a basis for disqualification from a work opportunity or a particular term or condition of employment. In short, entitlements should in general apply equally to workers whether male or female. Then, in addition, class, Labor Code provides particularly in Article 130 that no woman, regardless of age, shall be employed or permitted or suffered to work with or without compensation. However, Republic Act 10151 in 2011 provides that women can now work at night. So with this, in industrial, whether commercial and non-commercial, undertaking branch thereof between 10 p.m. to 6 a.m. in the following day. But the woman should be given period of rest not less than 9 consecutive hours. And of course, there should be established separate toilet rooms for men and women. Now, my question, class, is: does discrimination to women as regards to work allowed? The answer, of course, is yes, but that is when the job itself necessarily requires a particular qualification. Then the job applicant or worker who does not possess it may be disqualified on that basis. So this is known as a bona fide occupational disqualification. So class, this happens when certain attributes to a particular sex or gender as an essential requirement to the job or undertaking. But the employer cannot use this indiscriminately because the court has set certain standards that the employer must prove in order to justify the selective employment. So with this claim, class, you may take the case sample between Star Paper Corporation versus Symbol in 2006. Then another class is stipulation under the code against marriage. So in here, class, women employees should not get married. Second, women employees shall be resigned or separated upon getting married. And third is woman employee will be dismissed, discriminated by reason of marriage. In addition, class, employees are strictly prohibited in having a relationship from a competitor company. So you can refer to the case between Duncan Association of the Tillman versus Glaxo Wellcome Philippines Incorporated in 2004. So as if, class, these provisions unfairly encroaches. So if these provisions, unfairly encroaches on the right of the employer to protect its legitimate business, then marital discrimination may be allowed. Employees are strictly prohibited in having a relationship from a competitor company is a management prerogative. So in addition, class, the Republic Act 7877 or the Anti-Sexual Harassment Act of 1995 provides that the state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants for employment, students or those undergoing training, instruction, or education. So this Sexual Harassment Act was usually committed by person having authority, influence, or moral ascendancy over another that requires sexual favor. So in a work-related employment environment, class, this sexual favor are made for condition of hiring, re-employment, or promotions, or refusal to grant the employee may discriminate or deprive employment opportunities. But in an education or training environment, this sexual favor is made for a condition to the giving of passing grade, granting of honors, a scholarship, payment of a stipend or allowance, or other benefits. So this above acts would result in an intimidating, hostile, or offensive environment. Then last for the special workers are the housekeepers as provided in Article 144 to 152 and also under Republic Act 10361 known as the Kasambahay Law. Okay, so these are the provisions, some of the provisions for the benefit of the housekeepers. They are entitled for reasonable compensation, for just and humane treatment by their employers, for lodging, food, overtime fee, and medical attendance, that their contract should not to exceed 2 years and renewable. They are not required to work 10 hours per day, and 4 days they are entitled for 4 days vacation or per month with pay. Also, they are entitled for funeral service. It must be paid or must be given assistance, and their termination is only for a just cause. And of course, they have the right to demand of the nature of work and the duration of their service. So class, the labor code exempts house helpers from being entitled and the basic conditions of employment. But the law is not bereft of provisions aimed at protecting their rights, as it also provides for the basic rights that house helpers ought to enjoy. Now, the second classification of employees are those workers based on the nature of employment responsibility. One is the managerial employees. They are known to be the alter ego of their employee. So these managerial employees under labor standards. There are those who are managing establishments. They are officers or members of managerial staff, and they determine if the employees are covered by the labor code. Then the second are the managerial employees under labor relations. These are those who execute management, transfer, suspend, assign or discipline employees, but they determine if the employees are eligible in joining or forming union. So in addition, class, managerial employees are those employees of the organization who, by virtue of their employment, are entrusted with managerial functions in the organization. These managerial functions are those that involves planning, policy making, strategizing, leading, and controlling. So you may ask, class, when may an employee be considered a managerial employee? So this is when that employee is vested with the powers or the prerogatives to lay down and execute management policies in order to hire, transfer, suspend, lay off, recall, discharge, or assign or discipline employees. Then the second class is the supervisory employee. They are those who are in the interest of the employer. They recommend managerial actions and exercise authority, judgment, and discretion. In addition, class, a supervisory employee is the one who has authority to hire, to transfer, to suspend, lay off, recall, promote, discharge, assign or reward or discipline other employees, or to adjust their grievances, or effectively to recommend such action if in connection with the foregoing the authority. Then class, we have the rank and file employees. So under the labor code, the rank and file employees refers to those employees who does not fall under the definition of managerial and supervisory employee. They are actually the ordinary members of an organization or the ordinary workers in a company as compared to their leaders or managers. In short, class, they are not in any leadership or managerial positions in the organization. And these employees form the majority of the workforce in the organization. Then the third classification of employees are those workers based on functions to the business or industry. So one is the regular employee as provided under Article 280. They are those who rendered at least 1 year of service, either it's continuous or broken. Those who perform necessary and desirable in the usual business or trade, in that the nature of their work will determine the status of their employment. In addition, class, regular employee are those employee whose employment is reasonably expected to continue for longer than 2 years. Although such employment may be terminated earlier by action on the part of the company or on the part of the employee. Then we have the casual employee. He or she is engaged to perform activities which are not necessary or desirable in the usual trade of business of the employer. In this case, class, the work is done on an infrequent basis with no set schedule or time. Therefore, the employment is considered to be casual. So, class, under the Philippine law, a casual employee is one whose work is neither regular, project, or seasonal. So, even though a casual employee, he is entitled to all the rights and privileges and is subject to the same duties and obligations as is granted by the law to regular employees under or during the period of his actual employment. So, his employment is called fixed period employment. Okay, class, so that would be all for this topic. And for your activity, prepare a 2-minute news report or talk show on issues concerning the classification of employee or employees. Submit the output in the Google Classroom. So, just check for the criteria in grading your output. And for the references, you may check also the following slides. And please submit your output in the Google Classroom. So that would be all for this session, class. Thank you for watching. See you in the next video.